Hello, everyone. Welcome to our virtual roundtable on Asian law. Today, we are very fortunate to have an esteemed panel with us to discuss the findings from this book recently published by Kevin Tan and Ridwanul Hoque on constitutional foundings in constitutional foundings in South Asia. My apologies there. I got slightly confused because Kevin had previously published a book on constitutional foundings in Southeast Asia. So this is really his second book on constitutional foundings. Now, this is an impressive book that really takes very seriously the idea of origins, the way in which constitutions are founded, and to really examine how these founding moments affect the core values as well as the functions and roles that constitutions continue to play in 8 modern nation states in South Asia. The book looks at the constitutions of Afghanistan, Bangladesh, Bhutan, India, Maldives, Nepal, Pakistan, and Sri Lanka. And so today is as much an intellectual getting together to discuss the ideas in this book as it is a celebration of this amazing contribution that Kevin and Ridwan have created for this constitutional law scholarship. So without further ado, I will now hand the time over to Kevin, who will be moderating the session and introducing the rest of our panelists. Kevin, on to you.
Thank you very much, Jaclyn. Welcome everybody to our panel discussion. As you can imagine, an occasion like this, under normal circumstances, would have been done live, and we probably have all of you in Singapore sitting around a round table rather than us sitting, sort of pastiche-like on a screen. But things being what they are, this is the best that we can do, and so I want to thank everybody for joining us today. Today we have 4 panelists, 2 of them involved in the book. My fellow editor in the book, Ridwanul Hoque, who is here, and he's joined by one of the contributors, Ebrahim Afsah. And with us are 2 guests who will be commenting on the book, Mara Malagodi and Mahendra Singh. Ridwan is currently Professor of Law at the University of Dhaka and currently is in Darwin as University Fellow at the Northern Institute of the Charles Darwin Institute. Ebrahim Afsah is currently holding joint appointments as Professor of Islamic Law at the University of Vienna, as well as Professor of Public International Law at the University of Copenhagen. And he tells us he's actually back in Copenhagen as he speaks to us today. Mara Malagodi is assistant professor at the Chinese University of Hong Kong. She's been around. First time I met Mara, she was still doing her PhD in SOAS. So, well, in a sense, welcome back to Asia. Rather more on a more permanent basis. Mara is a person of many great talents, including filmmaking, and I really like to. And she's a specialist on Nepal. So thank you very much for joining us. Professor Mahendra Singh, MP Singh, actually needs no introduction. He's probably the most respected and well-published constitutional law scholar in India. MP was previously at Delhi National Law School and is currently at the Jindal Global Law School. So once again, thank you for joining us. For today, the format will be as follows. I will invite Ridwan to share his thoughts about doing the book, and then Ebrahim to talk a bit about some of the contributions in his own chapter, and they will each speak for about 10 minutes, after which I will invite Mara and Mahendra each to speak for about 15 minutes, after which we will throw the virtual floor open to participants who, of course, are most welcome to make comments and also to offer questions. For the attendees, I'm quite sure you are familiar with Zoom, by now there is a question and answer facility in the Zoom screen. So you may use that to pose your questions. And it could be a general question or could be directed at any one of the speakers. And what I will try to do is to curate them and sort of bundle these questions together and then float them off to the relevant speaker. So with that, let me invite Ridwan to get this going. Ridwan, please.
Thank you, Kevin. Can I take just a second to share my screen? So thank you, Kevin, for your nice introduction. Since the time is very small, little time, 10 minutes only. So I'll be starting very soon. But before that, I'd like to thank my co-panelists, especially Professor MP Singh. Thank you very much, sir, for giving us time. And Professor Mara Malagodi. So really, we have got two fantastic experts in South Asian constitutional law to comment on the book we are going to discuss today in this little time. The plan about my talk is very informal speech today. It's good that I won't present any specific research, and so rather I'll be presenting something very informally. So I'll be speaking a little bit about my experience with the book, the work, then something on the enduring relevance of constitutional foundings of 8 South Asian nations, and what's special about the book, about this book, and the book's contribution to the comparative constitutional law generally, and especially the phenomenon of intra-regional comparative constitutional law, or the value of comparing within ourselves in the global South. And I'll speak very little about my own chapter, which is here, chapter 4 of India and Pakistan. It's definitely about the making and founding of Bangladesh Constitution. Then I do not have actually any conclusion because it's not a formal research work. So I'll be thanking you and say as 1 or 2 sentences as a conclusion at the end. So generally, it has been a fantastic experience to be working with 10 or 11 people who are leading scholars on constitutional law on 8 states of South Asia. And it was a rewarding experience to work with Kevin, the leader in this field. Then it's more about learning. So I'm a very novice, new, or elementary student of comparative constitutional law. So while working through the book, I learned a lot, to be honest, very frankly speaking, from other colleagues about the constitutions from our surrounding neighborhoods. So it's very interesting because before working on this project, I did little or nothing about, for example, the constitution of Afghanistan or constitution of the Maldives, or for that matter, constitution of Bhutan. And I came to see that, there were some fantastic elements in these constitutions which we would have done better by relying on them when we did draft our own constitution. I'm speaking about Bangladesh, and also for that matter, speaking for India and Pakistan, for example. Then the theme of the book, for example, we asked the contributors to answer to 5 questions, so to make a framework. And if you look at the page number 3 of the book, so fantastic questions. I'll just take one example. For example, a question was, what were the influential factors at the time of constitution making? And those factors might be local political factors, or internal cultural factors, or external factors. And we saw that, I mean, say, for example, even some towering personalities had some influence on constitution making. For example, for India, Sir B.N. Rao, then also for Nepal and for other parts, Sir Ivor Jennings, something like this. And that's just an example of the framework of the book and my experience and my the point of happiness from myself. And well, I think, I mean, that's the framework within which each and every contributor has worked is fantastic, but definitely like any other work, we had limitations. Let me just give you one example of limitation from the perspective of making constitutional, founding constitution and accommodating the differences or cultural sort of disagreements within the nation. As an example, for example, if you look at the India or Pakistani chapters, you don't see very much detailed descriptions about the indigenous inclusion. But definitely that was a tension. So how to recognize the indigenous community or the people who we call other people, something like this. However, the good thing is that, for example, in the Indian chapter, you have references to Muslims, the scheduled caste, so who are normally the people who are excluded from discussion or discourses or constitution making scenario. There are definitely references, but maybe because of the limitation of the structure or just in a chapter, say, for example, it's absolutely difficult to grasp the constitutional development of India at the founding moment in a chapter. So I understand the problem, but overall, I mean, it has been a very good experience to be working with this book and to be interacting with a fantastic group of scholars on constitutional South Asian constitutional law. Then relevance of constitutional foundings, which is a major area of contribution of this book. So basically, Professor Kevin Tan and I were claiming that this is a study of constitutional history, and in which we do not see enough publications, enough work. And then we have also made this claim, although any given constitution, for example, is a living document, which basically means that the constitution grows with the time. But we are claiming that the foundings or the founding of a constitution remains relevant forever. So to whatever extent we look back to evaluate our present, as well as to chart our future, something like this. And as a focus, for example, the book looked at the method, process, and politics of first constitution making. This is kind of also new. You have lots of literature on constitution making, but the way we developed our style of working is unique. That's what we think. And then what's the specialty about the book? And definitely, I would say that the one specialty is the definition of founding constitution itself. I'm not going to detail, but if you look at these constitutions, say for example, Constitution of Afghanistan 64, Bangladesh 72, Bhutan 2008, India 1949, Nepal, we have got 2 founding constitutions, and Pakistan 1956, which didn't actually work or was short-lived. And we worked on Sri Lankan Constitution 48, the Maldives 2 constitution, 1932 and 68. So we defined in a way that is that the founding constitution is either a constitution that makes the transition from colonial period to an independent sovereign nation, or it might be something for some nations which is an instrument of democratic transition or transition to sovereign people's regime, something like this. And another important factor or specialty of the book is this claim that we have kind of a presupposition or belief that founding constitution should be very constitutional kind of thing, very democratic kind of instrument. But that's not the case. We took the constitution that gave the founding of a nation, and how was it that? What are where is false, something like this. So our claim was this: founding constitution may not necessarily be democratic, even if a democratic country. Then another important thing is of this book. Oh, sorry, I forgot this to say that one most attractive part of this book is the inclusion of 3 countries: Afghanistan, Bhutan, and Maldives. We have several books on South Asian constitutional law, but if I'm not wrong, this is the first ever book to include all 8 South Asian or SAARC countries from the perspective of study of the constitutions. There's one more coming, which is, I think, in the press, and Abby wrote a paper on Afghanistan in this book. This is still in press, so I'm not going to say the title of the book. It's coming from Melbourne or Oxford. But that even doesn't cover all 8 countries. And definitely Afghanistan is there. That's a new thing. So this is a fantastic contribution from my view, and also from the viewpoint of my co-editor, Professor Kevin Tan, I guess. Then the value of comparative constitutionalism, that book contributes. So it's a study of constitution making is a modern legal branch. Say, for example, we have United Nations guidance note just from 2009, and most of the constitutions, I mean, modern constitutions, are enacted in the early 60s or late 70s or early 70s. But here in this book, we have studied few constitutions which date back to 1940. Say, for example, the constitutions Maldives, 1932, for example. And it's a rich document of how comparative exercises happen within the field of constitutional design within the region. And for example, in the Maldives constitution, we see the inclusion of constitutional rights, fundamental rights, back in 1932, which is a fantastic job to be done. And also Bhutan and Nepalese constitutions could provide an example in that regard as well as. And for example, another aspect is, say, when Bangladesh drafted its constitution in 1972, so coming out of Pakistan as a sovereign state, it deliberately avoided any attention being paid to Pakistan constitution. But in my chapter, as I've argued, some things have spilled through the practices or through the culture. And for that matter, Bangladesh actually relied on Indian constitution. So it's a pretty interesting study. Yeah.
Can you please wrap up? Yeah.
Yeah. So I have to cut from here in my chapter, which is the making and founding of Bangladesh constitution. I'm not going to detail anything except the constitution conclusion of my chapter. So this is an autochthonous or revolutionary constitution. It started with 4 fundamental principles or the identity principles of the constitution or the nation: democracy, socialism, secularism, and nationalism. But immediately after 1972, we embraced a constitutional breakdown in 1975 that prolonged until 1991, when we transited to democracy. However, during this period, constitutional foundings remain a relevant point to check with. And the example of this, for example, after a deletion from the constitution, the principle of secularism, for example, in 2011, Bangladesh has restored the principle of secularism. But on the other hand, now the principle of secularism is placed side by side or along with the principle of Islam as a state religion, which is very interesting matter to see, because the definition of secularism means that there should be no state religion. But anyway, the thing is that, I mean, Bangladesh has done some exercises with fundamental principles from the perspective of founding principles, something like this. And my conclusion for Bangladesh was that the current slogan for development is incompatible with the constitutional founding goals, as well as the current tendency or the trend of democratic backslide is definitely incompatible with the constitutional foundings in Bangladesh. So thank you very much for patient hearing.
Okay, thank you, Ridwan. May I now invite Ebrahim, Afsah, Ebi, for your thoughts on the book and your chapter or anything else.
Thank you very much, Kevin. I don't have a presentation. I must admit that what you said before of normally having come to Singapore is a big disappointment, I must say, for me now, because coming to Singapore is always very much a highlight of whatever I do. And if you permit, let me start with a short anecdote. I'm on the editorial board of a journal. And lately we got a request by a group of scholars in the ongoing discourse that you probably are all aware of, demanding greater diversity also of this journal. And it's a journal dealing with Islamic and Arab law. So we discussed it in the editorial board. And I must say that I was very much opposed to their claim, because I said there are scientific standards and ways of collaborating that have nothing to do with race and origins and whatever, and we shouldn't cut corners on these. And I brought out the example of the way the law faculty in Singapore deals with these issues. Because I think you are in this respect very much a lighthouse in a sense, because you are obviously extremely diverse. You deliberately reach out to countries that are socioeconomically challenged. And I've now attended a large number of conferences in Singapore. And you really you go out of your way to make it comfortable for scholars from these poorer nations, from junior scholars, for people who are disadvantaged, and you bring them together without cutting corners. And so this book very much is an example of that approach, if you were going to call it the Singapore School of Legal Scholarship, which I very much appreciate, also being part of it. And when Kevin and Ridwan asked me to contribute Afghanistan, my initial response was, what has a country that is as dysfunctional as Afghanistan to offer to more advanced nations like Singapore, Malaysia, or elsewhere? And then it struck me that it's, as in medicine, often in the pathologies, you can see some of the issues that are apparent elsewhere clearer than you might be able to see in more normal situations. And Kevin and Ridwan gave us very clear instructions for this book. And I very much commend them for this, because it made our job much easier and it made the collaboration much more constructive. You told us you're interested in how things are formed and how they relate to the past and the present, and in particular the future. And you were interested in the existence, if any, of a constitutional dialogue, both in the country, across time, and across space in the region and perhaps globally. And that got me thinking whether in some of these places we could see, if you permit me the term of a constitutional kaizen, you know, the Toyota principle of constant improvement. There's some nations where you see the constitution, as Ridwan called it, a living document that is constantly improved in an ongoing dialogue. And then you see other nations with constitutions, however often they're made, there are stop gaps, there are new beginnings every single time you write a new constitution. And you told us our chapters should have three objectives. They should be exploratory about the process and the input that goes into that initial constitutional idea. And it should be exploratory about the forces that impacted the constitutional process, both economic, political, perhaps regional. And then we should try to put it into a theoretical model that would explain what is going on about the nature and the role of a constitution in the particular place that we investigate. In Afghanistan, I must say that this poses a number of questions. and challenges, because Afghanistan has had a large number of constitutions. But as Kevin and Ridwan already knew themselves and actually told me even before I had a chance to say something about the number of constitutions, there's only one constitution that could possibly be deemed a beginning, and that is the 1964 constitution, which might surprise now outsiders because they say, well, didn't you have one in 2004? I'll spare you the details. These are in the chapters why the 1964 constitution is prominent. And it has to do with the process in which it was delivered, created and then delivered. And here I think we have a general, and this is where Afghanistan, I think, serves us as a good model of comparison, because many constitutional laws follow the somewhat erroneous idea that there is a constitutional moment in which an anthropomorphized community in a sort of hero journey comes together, looks at the past and says, this is not a good past, let's leave it behind and move towards brighter futures. And there is unstated, many of our colleagues have this sort of biblical adage inspiring them, saying in the beginning, as in the Genesis, in the beginning there was the Word. And so the discipline seems to be interested, who said something, why, who uttered which words for what purpose. And that is an important investigation. But this presupposes that the word is powerful. And I think what a place like Afghanistan shows you quickly is that this notion of the word in itself being able to determine social outcomes is a problematic assumption. The other major assumption that many constitutional law scholars bring to the field is to look at the process of constitutional writing as a sense of communal team building. Some even would go so far to say it's a sort of group therapy, to look at past trauma, walk through it, talk through it, acknowledge debts, and then basically move on. And these, however trauma therapy and however important it might be for an individual, I'm not entirely convinced this is what happens in communal settings. It certainly did not happen in Afghanistan. The other point that Kevin and Ridwan asked us to look at is to look at the role of a constitution, the text and the process, as parts of the nation building exercise. Now, this needs a slight unpacking, and Kevin and Ridwan were very clear about what they meant. Nation building is a sense of communal, social, cultural creation of a community. And they explicitly told us this is actually not so much what they're interested in. They were particularly interested in also, in my view, much more important, state building exercise. How did this constitutional compact help creating the modern institutions of governance by delineating authorities, clarifying mandates, describing the structure of the state? And here we see, even in a place like Afghanistan, the constitution actually providing much needed guidance. Unfortunately, in the Afghan case, as we all know, this state collapsed and was re-wrote several times so that the constitutional guidance at no point was able to actually guide social actors. But it was attempted, and we could look at the text and define where it fell short. And I think here in the discussions we had while writing the books with some of the other colleagues, I certainly learned a great deal about institutional design and the shortcomings of this. With this, I would stop, so not to overtax your patience, and I look forward to Mara's and Mahendra's comments on our collective work. And let me once again thank Kevin and Ridwan for this wonderful opportunity. And I take you up on your invitation to Singapore.
Great.
In the future. Thank you very much.
Thank you. Thank you very much, Ebi. Now, may I invite Mara for your comments, please.
Thank you so much for having me here. It's been really a great pleasure to engage with this volume. First of all, many congratulations to the editors and the country expert. I think the book is a very fine contribution to both South Asian legal history and comparative constitutional law. I think the effort that you've made to include all the jurisdictions of South Asia is particularly commendable, especially in a subfield which has been historically so India focused. So today what I would like to do in my comments is to offer a few reflections that my engagement with the volume has produced, and perhaps raise some questions for the editors and contributors in light of future work that can build on this important volume. So what I would like to do in my comments is to explore this notion of constitutional founding in the South Asian context in a comparative perspective. And in particular, I would like to focus on three dimensions of this founding. The first one is the identitarian dimension, and it comes out very clearly in the introduction of the book and across the country-specific chapters. And I think both Ridwan and Ebrahim have raised the issue. So we're looking at the relationship between constitution making and nation building. The second dimension that I'm interested in, and that I think raised a lot of exciting questions, is the temporal dimension. So when is this founding moment taking place? How is the time frame of this sort of Big Bang constitutional moment identified? And then the third dimension is what I called incremental in a way. And this founding, in my view, is not extinguished at the moment of promulgation or even with the abrogation of these foundational constitutions, but somehow lives on. And I'm interested in that kind of notions of legacy and continuity that you identify very clearly in the introduction as one of the themes. So if I may go into more details into each of these three dimensions, starting with the identitarian dimension and this relationship between constitution making and nation building. You raised the point in the introduction that constitution making and nation building is also about the legitimacy of the state that is anchored in a notion of the political community for whom the constitution is drafted. And there is a relationship between this notion of we the people, or the notion of the sovereign, and the way in which it is articulated through the process and through the text of the constitution itself. So I really enjoyed the focus throughout the volume on this notion on state building and the way in which constitutional founding moments are really crucial in the enterprise, particularly in the South Asian context. And also there is an ideological element to this, and we're looking at modern constitutions as markers of sovereignty. So for a number of South Asian jurisdictions, the foundational constitution is somehow associated with the foundational political transition, a form of modernization. And it seems to me that a common theme is some form of independence from an oppressor. And of course, that is contextually sensitive and is different across different jurisdictions. So if we're looking at an external oppressor, we're looking at colonial power. So we're looking, for instance, at the transition to independence of India and Pakistan from the British Empire in 1947, Ceylon in 1948. When we consider the case of Nepal, for instance, we're looking at an internal transition from an internal oppressor. So we're looking at a change from domestic autocracy under the Rana regime through the only actually period in time of Nepali history which is referred to as a revolution, which is the Satsal Kokranti, which is the revolution of 1950-1951, year 7 in the Bikram Sambat calendar. And also what's interesting, and I think that there is a theme here that we can draw from the Nepali experience, that really the 1950s are seen in the Nepali context as the age of modernity, not just in terms of law, in terms of literature, in terms of art, and so on. When we look at Bangladesh, the oppressor is both internal and external in a way, and there is a discriminatory center that leads the secession of the country and its foundation. Foundational constitutions in this identitarian aspect seem to me also to represent a claim to autochthony and modernization combined. Also, I think it's interesting to unpack a little more the kind of vision of the nation that these foundational constitutions that you've all identified in the volume provide, and link that to the internal social hierarchies that underpin that particular way of imagining the nation. So to give a few examples of what I have in mind here, let me go through some of the case studies that you engage with in the book. So for instance, if I look at the case study of Pakistan, to what extent is the constitutionalization of the one unit plan for West Pakistan, centered on Punjabi dominance of the state and adopted in the 1956 constitution, a sort of chronicle of a death foretold with respect to the secession of Bangladesh 15 years down the line. If we look at Sri Lanka, to what extent was the lack of constitutional safeguards for minorities under the Ceylon Dominion Constitution of 1948 an early reflection of Sinhalese ethno-nationalism? And to what extent was that a sign that the new constitutional framework was not designed with the concerns of the Tamils and other minorities in mind? And this is something that Ivor Jennings came to regret very bitterly after the first wave of anti-Tamil violence in the 50s. So you can find traces of that in his own writings. If we take Nepal as an example of this and we look at the influence of King Mahendra after his coronation in 1955 on the drafting of the 1959 constitution, he's handpicking Ivor Jennings after seeing work in Pakistan on the litigation over the dissolution of the Constituent Assembly, the first Constituent Assembly, and his work for the Governor General. And this executive dominance is translated also into a symbolism that justifies and legitimizes the predominant role of the Shah Hindu monarchy and dredges up the old adage of Nepal being the last Hindu kingdom. So it's not just a question of the way in which the frame of government is designed, but it's also the way in which the representation of the nation is consonant with that form of government. So this kind of leads me to consider the second dimension of the foundings, which is temporal. So when is this founding moment taking place? And I was very intrigued by the selections made by the contributors across the volume and the choice of which constitutions were deemed to be foundational. And I think what's really interesting, and I think that's one of the beauties of this volume, is that different authors have picked different things. So in some chapters, it is effectively the first modern constitution. The example from Sri Lanka is one of those. And then you have a choice of different constitutions. I think in the chapters that Ebrahim has done on Afghanistan, the choice of the 1964 document, the choice in India of the 1950 constitution, and so on. So it seems to me that we're looking at, for the majority of the case studies, at the post-World War II phenomenon in terms of foundings. We're looking at the twin pools of decolonization from the British Empire in South Asia, but also the context of the Cold War, which of course in Asia is not very cold at all. I want to refer back here to some of the work I've done with a number of colleagues in a special issue that we edited for the International Journal of Constitutional Law in 2019 on New Dominion constitutionalism, and kind of look at this choice on the foundational moments through that lens. So for instance, if we look at the case study of India, India actually gained independence as a dominion. And for 3 really important years, between 1947 and 1950, it was effectively a dominion. There is a brilliant paper on this topic by our colleague Roy Day at the Yale History Department, in which really engages with the historical silence on the dominion period and the fact that it's almost elided. And I think Arun has done a terrific job in the chapter looking at really in a granular way at the different influence of constitution making, while choosing, of course, to focus on the 1950 Republican Constitution. But I think, and I think the choice is an obvious one to focus in the Indian case on the enduring Republican Constitution. But I think, there is also a lot of value to kind of think back about that silence. When we look at Pakistan, so we're looking at essentially 2 jurisdictions that start on an identical constitutional footing. A constitution produced in London, the Government of India Act 1935, as amended by the India Independence Act 1947. And I think it's quite interesting to look at the different trajectories here. And I think I was really interested in the Pakistan chapter and look at the focus on the 1956 Constitution and the treatment of the Dominion Constitution somehow as a backdrop of the making of this foundational constitution, which is of course very short-lived. And I think that's also something that came up in my own work on the litigation over the dissolution of the First Constituent Assembly, where the Dominion Constitution works both as a mold, so some of the features of the Government of India Act are replicated, but it also functions as an aversive borrowing model, so something that needs to be avoided. And we look at some of the features of the new constitution that the authors identify as enduring. So we're looking at the role of constitutional rights and the role of the courts. This leads me to think about one of the elements that the editors have identified in their introduction, and the fact that these constitutional experiences speak not just of a radical repudiation of the past, but most importantly of continuity. And that brings me to consider the final dimension of these constitutional foundings that I identified, and that focuses on the role of change and this kind of incrementalism and how that relates to these founding constitutional moments. So in many of these early constitutions, many of those did not survive. I think, we're looking at a number of cases in points across the case studies. I think, India and Bhutan are kind of notable exceptions to the constitutions that the volume considers. And the question that I'm interested in, and I think that is really fruitful for further work, is in what way do these documents and these processes remain foundational, even somehow past their expiry date, past their abrogation. And I think actually that was one of the themes that I thought was particularly exciting across the volume, to look at the element of endurance beyond abrogation. And I think there really is an element of path dependence with respect to constitutional foundings and this locking mechanism of certain aspects, which are not just a question of constitutional design, but I think it's also a question of identity and what kind of identity they promote through the process and to the text that they create. And if I look back at the Nepal chapter by Bipin, and I look at the way in which he treats the 1950s, I think there is a lot to be said there. And the way in which the monarchy is described and the anchoring in a particular vision of the Nepali nation is really something that endures and that becomes very difficult to dislodge. And so we're looking at the 2015 Constitution of Nepal, and we're still going back to those ideas of secularism, what's the role of Hinduism, even after the king's head has been cut off, so to speak. So even after the abrogation of the monarchy, some of those narratives that emerged in the 1959 Constitution live on. And I think I'm gonna stop here. I want to congratulate again the editors and the country experts on this excellent volume. Thank you so much for having me.
Thank you so much, Mara, for very, very thoughtful comments. I'm quite sure, we have something to say about that in response in a while. But before that, Mahendra, the floor is for yours now. You need to unmute.
Yeah. Congratulations to both Professor Kevin Tan and Ridwanul Hoque for having brought together these constitutional foundations or foundings in the SAARC, eight SAARC countries, which work was not done before because either all the constitutions were not covered or because the discussions were in a way diverse on different issues, and therefore, despite of the fact that Khilnani and Raghavan, they tried to do it, or before that Professor Kumar Singham did it, but the work was not as comprehensive as the present work is. And for that, definitely so far as Professor Kevin Tan and Professor Ridwanul Hoque, both are actually to be congratulated. The present work, of course, fulfills that requirement, and the requirement, however, in some ways remains to be done again and again, which I will come later on. But so far as the present work is concerned, I consider it to be a very good beginning by which, of course, beyond that we can go further, and maybe either the two editors in this book or maybe different authors come together to actually pick up the threads where they have been left in this current book. As the last speaker in a way for today, and also just to seek guidance, I wrote to Kevin Tan that what could be said in 15 minutes about the book, and he gave me certain hints. I need not tell that secret to everyone, but of course I would follow those hints for the purpose of my presentation, and they, I found, are quite quite covers the whole book as well as the idea of writing the book. The two key assumptions so far as this book is concerned, I'll come to the other aspects later. According to authors, are that the constitutions actually are not a complete break from their past. This is one assumption, that something of the past of those countries is reflected in their constitutions. And unless it is reflected, the constitutions may fail also. It's another matter that they have failed in spite of that reflection. But that reflection is quite essential, and that must be there. And then so far as these constitutions are concerned, that they lay down the foundational framework. They just, so far as these constitutions are concerned, though of course it may not be said about all the constitutions in all the countries. Maybe, for example, the Constitution of India is an exception to that in the sense that it is not only detailed, but some of those aspects of democracy and the rights of the people, they have also been covered in detail so far as that constitution is concerned. But so far as the other constitutions are concerned, they broadly lay down a framework for the working of the constitution, but are not necessarily providing all that is required for a constitution to be successful. So in the light of this background of this book, a few things that I would like to actually praise so far as this book is concerned, and as I have liked it for those reasons that one, it fulfills the gap that existed about the constitutions and constitutionalism in SAARC countries. And that is one important aspect that has been covered by the book. The book also tells us what makes a constitution successful and what leads to its failure. This also comes very clearly out of the contributions which the authors have made, but in their detailed introductory chapter, the editors also perform that job very well. And then so far as the individual countries are concerned, they have their individual or distinct problems. And for them, they have to find answers. And by reading these chapters from different experts, we find that those aspects have been covered, and that uniqueness of each country is represented in their constitutions. So that is also then so far the other aspects which I think in some ways are not as praiseworthy as the 3 points which I have just mentioned. They are that the chapters in the book, they lack uniformity in their contents as well as the description of all the chapters. That is, some of them are very detailed. For example, the first chapter or the second one by Arun Thiruvengadam, it is so detailed. So far as the other chapters are concerned, some of them stop when the current constitution comes for discussion. Ebrahim, for example, has very well justified so far as 64 constitution is concerned, because he actually positions the 64 constitutions and it's really a wonderful chapter in the sense that the true spirit of Afghani people is represented in the 64 constitution. And it seems that now I can understand that why one of our former students from Afghanistan at Delhi University, when I met him a few years later in Columbia, New York, he was very angry that we supported or we were friendly to USSR at that time, and in a way allowed the Russian forces to enter Afghanistan, which destroyed the country. Otherwise, they were very happy under the Constitution of 64. Now, after reading Professor Ebrahim Afsah's paper, I realized that why they were so much attached to that Constitution. And it is that aspect which actually has to be represented in every constitution. And for that reason, in spite of the fact that it is a shorter paper and it stops at 64 and doesn't take into account the new constitution which has been made in the country, but there is a good justification for that. Now the similarly, so far as other constitutions, Sri Lanka, for example, it stops at Salisbury's constitution. Why not subsequent constitutions? Pakistan also the same way, Nepal also the same way. Nothing has been said about the current constitution, which is functional at the movement in those countries. But so far as Afghanistan is concerned, that Professor Ebrahim has done remarkable work, and I must appreciate the justification for stopping at some point, which may not be the final point so far as a constitution is concerned. So therefore, so far as this book is concerned, there are certain things which one can carry on with oneself for the purpose of further thinking as well as further scholarship. And that is that for making a constitution successful in any country, I think something from scholars like Carl Schmitt, for example, of Germany, that has to be taken up, that you have to create first, collect the people together and create a state. And it is in that state, state is a body in which people by and large agree on certain fundamentals. And unless the people agree on those fundamentals, the constitution which is made later on would never be successful. And in quite a few countries, in the 8 SAARC countries, or rather most of the countries, India is an exception, but otherwise in most of the countries, the constitutions have not worked beyond a few years, and each time they have to be revised or rewritten after being rejected. The other aspect is that there is also a need of organizing the people and educating them in the aspects of the constitution. Unless that that aspect is there, that is, the people are not involved in the making of the constitution and in understanding what the constitution is saying, there is every chance that the constitution will fail. And therefore, the participation of the common man in the making of the constitution, or understanding about what kind of constitution they would like to have, is essential. And those who make the constitution, they must take that into consideration while making that constitution. And this, just to tell about India, it's not that I'm just praising India, but because this is the constitution which has been working since 1950, though of course with 103 amendments, which is too much, but it is still somehow functioning. And this is happening because people were, by and large, they were involved with the making of the constitution or before the making of the constitution, and then their elected representatives actually made the constitution, and they kept in mind the interest of every single individual or group of individuals in the country while they were making the constitution. Therefore, what I would like to see in case the book is revised or something has to be done on similar lines in future, that it must describe essentials for making a constitution successful in any country. That that is, what are the conditions that must be satisfied before making a constitution? It must also emphasize on the active participation of the people in general in the making of the constitution, and the participation of the people in the constitution making process also is the foundation for democratic constitutionalism. And that is also true that so far as the Constituent Assembly is concerned, many congressmen actually vacated their seat in the Constituent Assembly to bring into the Constituent Assembly the members of the opposition parties, so that all parties, political parties were represented in the constitution making, and their views were not only heard, they were also incorporated in the constitution making. Now, so far as further suggestions in respect of the constitutions are concerned, let me towards the end say very clearly that whatever statements I have made about the book, the negative points should not be taken as a criticism of the book. Really, so far as Professor Kevin Tan and Ridwanul Haque are concerned, they have done a remarkable work by selecting really learned people from different countries who know about their constitution, or persons like Professor Ebrahim Afsah, or that lady Winnie, so far as Constitution of Bhutan is concerned, that these are the persons who may not be citizens of Afghanistan, they may have not lived in Afghanistan, but they have studied it very closely. The lady Winnie actually has been in Bhutan for quite some time. Perhaps she has done a lot of work on that, and therefore the kind of work she has represented in her paper here, that I could not hear even from the Bhutanese people, including Professor Sonam Tobke, who was the chairman of the Constitution Committee, which drafted the Constitution, and he was also the Chief Justice at that time, and his successor Chief Justice also, I have heard in great detail, but the kind of insight which Lady Winnie has given, that was somewhat not told to us by these persons from Bhutan. Maybe they thought that they were not important, but I think they were quite important, that the constitution is not a representation necessarily of all Bhutanese people, but it is perhaps an idea which came to the king, and the king also, knowing well that things are going to change, therefore it is necessary that the constitution must be changed. These are some of the lessons which can be taken from these writings, which again I would praise or I would say, so far as Professor Ebrahim Afsah's paper or Winnie's paper are concerned, they must be for that reason be taken seriously into account. And I'm sure that Professor Kevin Tan and maybe along with Ridwanul Haque or some other colleague, he will continue to work further so far as South Asia is concerned, and maybe not exactly on these countries, but on some other countries of South Asia. A new book will also come in future, which would be, of course, an improvement over what he has done so far. So with that wish, I close and again congratulate both of them, and also the authors who have contributed to the book, whoever are here or whoever are listening in their own countries. Thank you very much, Kevin Tan and Ridwanul Haque, for giving me the opportunity to speak to all of you. Thank you very much.
Thank you so much, Mahendra. Very thoughtful comments and certainly a great agenda for more work that could be done. And you know, I will just abuse my privilege as the moderator for a little while, since I'm the other co-editor of the book, in the sense that when we put this together, we did not think that we were doing anything exhaustive. It was a start. And it's important to always get a start, in the same way sort of foundational constitutions get a start on things. And then we need to see how that translates. And obviously one hopes for greater continuity rather than disruption along the way. So, you know, thank you very much for those comments. So before I take the questions from the floor, and so far I've seen only one question so far. We'll come to that in a little while, but whether Ridwan or Abby would like to respond to the comments that have been made by Mara and Mahendra. Abby?
Thank you, Kevin. I really liked Mara's sentence that I wrote down about the chronicle of a death foretold. She mentioned it in the context of the Pakistani collapse. And I think it's a very, it's a catchy way of summarizing a general problem that we see in a large number of countries in the South, actually not only in the South. And I see it more as a sort of having my work cut out for the future, rather than now being able to respond to it. But it's a real problem of where in the constitutional compact we can find the origins of that collapse. And that is an important work for constitutional scholars. But already I think we need to guard against over privileging our own expertise and our own field and interests, because part of the things in the Afghan constitution, and I see it also as a German citizen, we have the same problem in our own constitutional history. The text will always be only so important and only going so far. What is necessary, and the German constitutional law scholar and judge on the Constitutional Court, Böckenförder, once said, any constitution is relying on elements that it cannot create itself. We could maybe summarize it as a constitutional culture, a democratic culture. And this is the question, where does it come from, and can you actually actively create it or help it come about? And here I found Professor Singh's comments very helpful to me, because as he was talking about the nostalgia in the Afghan community to the 1964 constitution, which is a very palpable, to this day, very palpable, very strong sentiment that you feel absolutely everywhere. People have photos of the Constitutional Convention in their shops. You know, these are illiterate people. These people have pretty much, you can be certain that they have not read the Constitution as such. But this nostalgia is reflective of a period, and this is both of you, both Mara and Mahendra, you referred to this, what it means to be a state. And I think at the very basis, it means an agreement not to kill each other. What Karl Deutsch, the German Jewish exiled political scientist, called a security community. You come together to disaggregate your disagreements and to agglomerate those areas where you agree. And there is, exactly as Mahendra said, and I think this is very important, it requires people to agree on certain fundamentals. These don't necessarily have to be value fundamentals, but there needs to be a very basic, and I think this at the absolute bottom is the agreement not to kill each other. And in the Afghan constitution, and in the Afghan setup, this is an agreement that disintegrated very quickly after the compact was founded, already in the 70s, well before the Soviets came. And in my text, I quote Dupré, who's probably the best scholar on Afghanistan. He calls it the utter dispiriting and irresponsible nature of Afghan politics. And as Mara and Mahendra were talking, I thought the same description would apply to Pakistan. It's an utterly irresponsible politics. And I think our challenge as scholars, and here we would probably have to work with other disciplines, is how do we explain this? And I think there's lots of work on to explain it, but the real challenge is how do you get beyond it? How do you create what Böckenförde called the fundamentals on which a constitutional order relies, basically moving away from irresponsible politics to law-bound, value-bound politics. And I don't obviously have an answer, but I think it gave me a lot of food for thought into how to move on and how to work on. And just one last thing, Mahendra, just to clarify, I'm not an Afghan myself, but I did live and work in the country for 10 years. And on this, I think it's important that also non-nationals engage in the discourse on a country's politics. It's not something that should be exclusive to members of that community. Thank you very much.
Thank you, Abby. Ridwan, you'd like to say something in response?
Not that much. Thank you to both the esteemed panelists. I liked Mara's identitarian aspect of these founding constitutions. Thank you very much, Mara. Yeah, so that's the identity searching kind of thing. And to come to Professor MP Singh, what was fascinating for me is his critique that we probably failed to articulate the preconditions for the endurability of a founding constitution. It's fantastic. I have a new work to do on constitution making from Bangladesh perspective with Mara. You know that this will help me a lot, sir. But on that point, I'd like to make a point in reference to our book. We actually invited our authors to say a little bit about the impact of the founding constitution. That actually covers, I mean, whether it has been able to endure or not. But it's interesting that in many cases of South Asian constitutions, 8 of the 8, many didn't actually endure, or many didn't have a lasting impact. Say, for example, Bangladesh had a major change. We had a mini constitutional revolution change in 1975 from parliamentary democracy to a one-party presidentialism. And that happened to a constitutional amendment and made by the very political party that led the country all the way through to independence. And people were suspicious. Was it for example, unprincipled or sort of unpragmatic incorporation of Westminster style of democracy, or was it for the inclusion of secularism in Bangladesh constitution without the, participation of the people, or without a consent of the people? I mean, to what extent the people agreed to see secularism in their constitution, because it's a mostly majority country. So all these questions came up, but yes, me personally, for example, I did not dig deep into that. Yes, it's a fantastic observation from your part, sir. Thank you very much.
Thank you very much for your responses. I mean, if I may chime in a little bit on some of the ideas in the conception of the project. Initially, when I first worked on the first volume on Southeast Asia, I thought it would end there. I didn't think that it would go beyond Southeast Asia. And then I had a chat with Ridwan, and I thought, okay, maybe we can do South Asia. And of course, right now I'm doing the finishing touches of a volume on Northeast Asia. So by the time the 3 volumes are out, we've actually got, you know, sort of the countries in sort of, you know, Asia covered. We don't do Central Asia. I don't know anything about Central Asia at all, but at least Northeast Asia, Southeast Asia would be covered. And the original objective to go into this enterprise was really the lack of materials discussing these various jurisdictions. You know, if you look at textbooks, at least those available in the English language, textbooks and treatises on constitutional systems, constitutional history, and so on, you will find a lot of stuff on India, because Indian scholars have been very actively working on it. You'd see some stuff on Pakistan. You see a lot on Sri Lanka or Ceylon, because again, there's a tradition of scholarship where there's a lot of stuff. But come to Bhutan, the Maldives, Afghanistan, it's a blank slate. You don't have anything going on there. It's difficult. So, so we wanted to get a start on this. And I very much appreciate what Mahendra has said, that maybe we could do more to talk about what's really going on. But I think then the book would be 3 times the size, because that was not the object. But I appreciate that this is something that is really quite important, that we need to investigate as we go along. So small steps, legal continuity. I think this is something. But Mara, I really loved your comments, and in particular the temporal part. I mean, this is something I thought about for the longest time. Do I tell the authors which one they should say talk about based on just my sort of very broad general knowledge about these constitutions, or should we let them choose? And at the end of the day, of course, we thought, well, you know, the first thing is to identify an expert, or someone we regard as an expert, someone who could give important insights into the process, the making process, and let them decide. And that's how we came up with the sort of group that we did. And like Mahendra, I was very, very happy with what Winnie Booth gave us. Winnie, unfortunately, is not with us in the session today, and I think academia has lost her to the world of yoga. I think she's much happier doing yoga classes and teaching yoga now than writing about Bhutan or parts of South Asia. But she came to it with a sort of a political anthropologist's mind. And so with that perspective, you start looking at things that maybe we as constitutional scholars take for granted, and so having, I wouldn't say foreign, I mean, curious eyes, looking at things in slightly different perspectives, cast things on things that, on events and elements that we often miss because we just assume that it's always there. So that much for my responses to your comments. I really do appreciate them, and thank you very much. So let me now move on. There's only one question, so I'm gonna take this from Professor Muhammad Iftikhar of Eastern University in Bangladesh. He's directed this question to Ridwan. He said, as you referred in your conclusion that the current development of Bangladesh is incompatible with the original constitution, which arrests his attention to the issue that so far the present government has never been challenged for deviating from the said originality, neither in the apex court nor in the parliament. Do you agree that there are elements of inadequacy in the constitutional framework to check this? And if so, is it a foundational defect of Bangladesh's constitution, or is it merely a political manipulation that has made the constitution look as if it were inadequate? Wow. Ridwan.
Thank you, Iftikhar. Honestly, it has been a fantastic question, but I'd be brief. By saying that, I mean, current development is incompatible with the founding goal, I was referring to the founding goal of development, which was transformative development, social inclusion, not at the cost of democracy. And also, say, for example, one of the fundamental principles of Bangladesh constitution was to prohibit unearned income, so to kind of prohibit corruption. So since we have a big dent into democratic fabric of Bangladesh right now, and as I have mentioned, it's a democratic decline. And so the current development is far away from developmental goal. But the reason that the government is not challenged in the court or in parliament is different. The constitution doesn't keep a room for challenging the government for failure to make constitution compliant development in the court, because it's a fundamental state policy principle kind of thing. And so it goes basically to the political constitutionalism. We also don't want to see court challenge asking the court to say that this development is unconstitutional and you stop it. No, we don't want to see that. So it's not a problem of constitutional designing. Rather, I like it. So it goes to the political constitutionalism. And the reason why the government is not being questioned in parliament is I mean, absence of democratic culture right now, and I mean over consolidation of power within the government structure. So parliament is kind of dominated by executive. So that's another reason. So fantastic question. Thank you very much.
Right. I don't see any more questions, but we still have a little bit of time for more questions. But before that, I mean, we've been talking so much about the book. I thought I should at least show what this book looks like. This is how it looks like. And there is a discount code for those of you who signed up for 20% discount. So please, I hope you will go out and get yourself a copy. If not, recommend it to your library. I want to also express our deep thanks to the authors. I have just gone through the attendees list, and I know that there are 4 of our other contributors who are online with us. Arun is here with us, Moin, Chima, and Sadaf Aziz, who both did the chapters on Pakistan. Arun did India, and Roshan, who did the Ceylon stroke Sri Lanka chapter, is also with us online. So, I want to thank all of you for the contributions you made towards this book. Any other comments or questions before I wrap this up? And finally, of course, the Center for Asian Legal Studies at my university, National University of Singapore, was instrumental in allocating the funding for the research involved in this book. Alas, we couldn't use most of it because we were supposed to have everybody fly into Singapore, and we couldn't quite do that for at least for the launch event. So another time. Abby, please.
Kevin, just as you were describing before your other many projects. First of all, I'm very much looking forward to reading your book on the Northeast Asia, but I just would like to suggest that you don't dismiss so easily and out of hand something about Central Asia and Western Asia, which perhaps could be done together, because I think the approach you brought to this field is needed. And while there is lots of work on Western Asia or the Middle East, there is very little on Central Asia. And I think it is a very interesting region. So I would try to encourage you not to, or perhaps to find it in your soul to take on this project as well.
Well, no, I only said I don't know anything about it. I mean, I probably have to talk to Scott Newton because he's done a lot of work on Central Asia. If there are people who are happy to work on it and collaborate, I'd be happy to work on it as well, and to also And I'm quite sure, well, Jaclyn's listening in. I'm quite sure I could persuade Jaclyn to give us funding for that as well from the Center for Asian Legal Studies. So we're okay there, right?
I can volunteer.
Fantastic. Abby, we will take this conversation offline. Well, if there aren't any other questions, then, you know, I would bring this session to a close. But first, let me thank Ridwan and Abby for joining us. And thank you very much, Mara and Mahendra, for your very insightful and very helpful comments, and for, in a way, helping also chart the way forward for more research into constitutionalism in Asia. Thank you very much.
And from my part, thank you all, especially my co-authors of this book project, who are here and who are not here today, and especially to Professor MP Singh and Mara Malagodi for being the commentators today. Thank you so much. Yeah, I'll see you sometime again.
Thank you. Bye-bye.
Bye-bye.